Judgment in the matter of News Corp UK and Ireland Limited against Commissioners for His Majesty's Revenue and Customs.
Lord Burrows will explain the decision of the court.
VAT, value-added tax, is charged on most goods and services, but there are exceptions. The exception with which we're concerned in this case is for newspapers. Under Section 30 of the VAT Act 1994, newspapers are zero rated. The question in this case is whether that exception, that zero rating, should be interpreted as extending beyond print newspapers to what I shall refer to as digital editions of newspapers, that is, editions for e-readers, tablets, smartphones and websites. As from the 1st of May 2020, there is no dispute because by valid secondary legislation, zero rating has been expressly extended to newspapers when supplied electronically. But what about the period prior to when that secondary legislation came into force? News Corp UK and Ireland Limited, which I shall refer to as News Corp, argue that in the pre-2020 period that has been specified to test the question, which was the 30th of August 2010 to the 4th of December 2016, they should not have had to account to the Commissioners for His Majesty's Revenue and Customs, HMRC, for VAT in respect of digital editions of their newspapers, namely the Times, the Sunday Times, the Sun and the Sun on Sunday. Their claim was rejected by the First-tier Tribunal, accepted on appeal by the Upper Tribunal, but rejected again by the Court of Appeal. News Corp now appeals to the Supreme Court. The Supreme Court unanimously dismisses News Corp's appeal. The correct interpretation of newspapers in the exception contained in the VAT Act 1994 is confined to print newspapers and does not extend to digital editions. The leading judgment is given by Lord Hamblin and myself, with whom Lord Hodge and Lord Kitchen agree. Lord Leggett gives a separate concurring judgment. There is a principle applicable to domestic statutory interpretation that a statute is always speaking. What this means is that as a general rule, a statute should be interpreted taking into account changes that have occurred since the statute was enacted. Those changes may include, for example, technological developments, changes in scientific understanding, changes in social attitudes, and changes in the law. Very importantly, it does not matter that those changes could not have been reasonably contemplated or foreseen at the time that the provision was enacted. The great merit of the always speaking principle is that it operates to prevent statutes becoming outdated. It would be unrealistic for Parliament to try to keep most statutes up to date by continually passing amendments to cope with subsequent change. Jonathan Peacock KC, counsel for News Corp, submitted that this case is a classic example of where an always speaking interpretation is appropriate. This is because, he argued, the facts concern a technological development from printed newspapers to digital editions, where the policy or purpose behind the VAT zero rating carries through to the new development. And it's not in dispute that the social policy behind Parliament's decision to zero rate newspapers was the promotion of literacy, the dissemination of knowledge, and democratic accountability by having informed public debate. And that social policy is just as applicable to digital editions of newspapers. That was an attractive submission put forward on behalf of News Corp, not least because of its rational simplicity. But ultimately, we were not persuaded by it for a number of reasons. Most importantly, the question we have to answer is not just a matter of domestic law. The law on VAT is also dependent on EU law, European Union law, and it's common ground between the parties that the withdrawal of the UK from the EU, Brexit, has had no impact at all on the issues in this case because they concern a period prior to withdrawal. What EU law relevantly dictates is that first, an exemption from VAT has to be strictly construed, and secondly, there is what is known as a standstill provision to the effect that VAT zero rating could not be extended beyond what was permitted as at 31st of December 1975. It's also relevant that zero rating for newspapers was seen as a transitional phase, with the ultimate purpose being harmonisation across the EU with no VAT exemptions at all. In our view, the impact of that restrictive EU law is to curtail severely the operation of the always speaking principle. Moreover, the move from print newspapers to digital editions is not a minor change. It involves a conceptual change from newspapers as goods to newspapers as services, and digital editions open up all sorts of possibilities for interactive communication, including videos and audio links and updating that are not possible with print newspapers. Certainly, it is not irrational to distinguish between print newspapers and digital editions, as borne out by the fact that EU VAT law has itself drawn that distinction. We accept, and it's not in dispute, that changes to print newspapers, such as being produced by computer rather than hot metal presses, containing colour rather than black and white photographs, are covered by the always speaking principle and fall within the EU law constraints. These examples, however, do not involve the adoption of an impermissibly expansive approach as would be required to include digital editions. Therefore, having regard to the constraints of EU law, the always speaking principle cannot be applied so as to interpret newspapers as covering digital editions prior to the change made by valid secondary legislation applicable as from the 1st of May 2020. In addition, the principle of fiscal neutrality, which requires that similar goods and services be treated the same way for VAT purposes, does not support News Corp's case, since the court has not found that some forms of digital edition were to be zero rated, while others were not. Lord Legate, in his concurring judgment, comes to the same conclusion, but by different reasoning. He challenges the conventional approach to the always speaking principle. In his view, the proposition that statutes are to be interpreted as always speaking is stated at too high a level of generality to be meaningful. Rather, there are different types of change that may occur after a statute is enacted to which different considerations apply. On the facts of this case, which are concerned with technological change, the principle, according to Lord Legate, has no role to play and should be put to one side. Nevertheless, he concludes that it's not possible to say that the intended effect of adopting an exceptional tax treatment for newspapers must be taken to have included applying that treatment to digital editions, which are significantly different from print newspapers. Given the requirement of EU law to interpret the term strictly, the narrower possible meaning of the term newspapers must be preferred, which treats printed form as a defining characteristic. The appeal of News Corp is therefore unanimously dismissed.
The court will now adjourn.